All right, so welcome again to ARI's last knowledge exchange event. Before we start, I just want to quickly go through the agenda. We're going to do the introduction, and I'm going to leave the floor soon to our key speakers. But I wanted to just share about ARI's work and activities before. So ARI started in 2018 in partnership with Refugee 613, as we saw that settlement workers and the sponsorship agreement holders or private sponsorship community in general are natural allies with the common goal of supporting sponsored refugees better. So we identified the difficulties in communication and clarity and collaboration. So through research and assessments, we concluded a lot of promising practices that we tested during the first round, and the main two practices were the intentional connections that we make between the settlement community and the private sponsorship community, and the knowledge exchange, which is to continue to allow the discussion and conversation virtually between the two communities. Building on that, ARI was funded by the IRCC for a second round, ARI 2, from 2021 until 2025. And the goal is that partners like settlement agencies and sponsors deliver responsive and coordinated settlement and community services for sponsored refugees. So that is still at the intersection of settlement and sponsorship, but is aimed to build more capacity and implement some of the ideas that we tested in the first round. So the two activities of ARI right now are the knowledge exchange events, which is what we're doing right now, which is a series of virtual webinars and roundtables to bring together settlement and sponsor communities to share info and build understanding. And the ambassador agencies activity, which is basically supporting the SA and SBO partners to implement elements of the best practices that we identify through their mutual work, basically to allow them to collaborate together and work in partnership. So that's pretty much what we do. This is the fourth and last webinar for this year. We will have a new series of webinars in the next year, starting in next April or May. So if you need to know more, or if you have any questions, you can contact me. I'll leave my email in the chat box. So I would like to now introduce our key speakers today, and our topic today is the today's webinar is about anti-racism and anti-oppression in the sector, in particularly in terms of the refugee process. We will be talking about the systemic racism and oppression, whether from refugee claimants from inside Canada or from outside Canada, and from a legal perspective, what are the rights of refugees? What are the rights of private sponsors? How can we advocate for refugees? Also, we will learn more about the complexity of different forms of systemic oppression at the intersection of race and sexual orientation and gender identity and expression, which means multiplying layers of oppression and discrimination, which also tends to make it more difficult for refugees to even engage with the process. So the process favors more economic refugees, more privileged refugees to access the justice that they deserve. So we will talk about all these things and the efforts that we can make, what is being done, what are the activists and advocates are doing, and how can we also, as advocates of refugees, of refugees and settlement workers, how can we engage more constructively in this conversation? So I would like to introduce our key speakers today, Adila Crossley and Dr. Martin Mark. Adila is an immigration and immigration lawyer and activist and family law lawyer as well. Adila has been practicing in the area of immigration and refugee law and family law and child protection, and she's providing legal assistance to refugees consistently, and she's also active in supporting the refugee and settlement sector and organizations. She has solid relationships with many community organizations and churches, and provides advice and assistance to many. She's the referral lawyer for community organization and shelters, and consulting lawyer for the Mexican consulate in Toronto. She's also on the board of directors for the FCJ Refugee Center and the advisory board of the Office of Refugee Archdiocese of Toronto, ORAT. She has an extensive litigation experience as well. So she appeared before various tribunals like the Immigration and Refugee Board of Canada, and she regularly appears before the Federal Court of Canada, the Ontario Court of Justice, and the Superior Court of Justice. And she continues to be a passionate advocate for marginalized, non-status individual and racialized communities and immigrants. Also we have with us, thank you, Dr. Adila, for being with us, and I'm looking forward to hearing from you. I want to also introduce Dr. Martin, who's been also an advocate of refugee and migration and social justice for over 40 years, particularly advocating for refugee rights, civil liberties, human rights of detainees and marginalized groups and people in need. He's a frequent in the United Nations High Commissioners for Refugees annual meeting in Geneva. He's also worked in the Refugee Sponsorship Training Program, the RSTP, and at the Afghan Women's Organization and the Catholic Cross-Cultural Services. And between 2001 and 2017, he coordinated the refugee resettlement work of the Roman Catholic Archdiocese of Toronto and served on the NGO Government Committee on Refugee Sponsorship and on the board of several other organizations. Lately, he's focused on refugee and migration-related work on research, advocacy, and in the private sector. And he continues his charitable refugee and resettlement activities at the Christians Walking with Refugees project and the Worldwide Opportunities for Women and the Canadian Resettlement Society. So thank you again, Dr. Martin, for being here today. And I like, without further ado, I'm really excited to hear from both of you. So enough talking from me. I want to leave you the floor. So I will like Dr. Adila, you can start.
Thank you. Good afternoon. I do want to start off by saying that Dr. Martin is a very dear, close friend of mine, and I'm so honored to be in the same panel as he is. Dr. Martin, in my view, is a person that not only says something, but he actually does what he says. And he has gone to refugee camps all over the world and looked at the most vulnerable people and resettled them. So for me, it's an honor to be in the same panel today as Dr. Martin, and I'm excited about that. And I want to talk about, you know, the role that race, culture, and something we don't often talk about when we talk about refugees and things that affect their ability to present their cases, their level of education, their socioeconomic status, their ability to advocate for themselves. Like all today, since early this morning, I've been in a day-long hearing with a very vulnerable young man that is from Mexico. And a lot of things flowed because of the lack of interpretation he had when he arrived in Canada from Mexico. And had he had access to adequate and proper interpretation, I don't believe we would be where we are with him today in his legal path, so to speak, right? But he had sometimes, you know, he said there were like 5 different interpreters on the phone interpreting the same interview. And so they thought he said something. It was never read back to him. It was just recorded as his answers. And he never realized until a couple of years later that this was recorded. And so it really brings into question the fact that we look at, you know, refugees, and the most important issue when we look at hearings is that of credibility. And what is credibility, right? Credibility findings are made based on a number of factors that may have nothing to do with the actual refugee, but our perception and our biases and our lack of empathy and our inability to really ask the right questions, our unwillingness to ask the right questions. And so as a lawyer that I've been doing this for close to 2 decades, you know, when I look at decisions that clients come to me and they may have been denied, and when I look at the basis for the denial and if it's credibility, let's take, for instance, an actual client of mine, a member of the LGBTQ community from Honduras. Now, Honduras is a very dangerous country to be a woman and to be a member of that community. And when you intersect the two, it creates a very dangerous situation to return to. And my client came from a family where her parents and her grandparents were evangelical pastors in a church. And so she was very afraid to even, you know, identify, let's put it that way. So when she went to her hearing, she got a board member that expected her to behave in a certain manner, consistent with his idea of what a member of the community would say, would do, and would behave. But it had nothing to do with the reality and specifically with her reality. And so she was denied on credibility. And he even went so far as to say that it's not reasonable that if she was really gay, can you hear me?
Yes, we can.
Okay, because I think I lost you for now. It just went blank. I'm gonna try to rejoin. I don't know what happened.
Okay.
Okay. Can you see me?
We can see you and hear you clearly.
Okay. All right. Because the screen just disappeared. I don't know what happened. All right. I'm going to talk even though I can't see anyone. And okay. Yes. So she was denied of credibility. And, you know, it was really, really sad. If you come to Canada, and I'm going to talk specifically about inland claims, because I know that Dr. Martin will speak about adjudication of overseas claims and overseas refugees, because he has worked for ORAT and for SOS for so many years. But if you were to come to Canada from the United States, something that is such an anomaly and such a perversion of the law. If you were to do everything by the book, so to speak, and you file your refugee claim at the port of entry through an exception to the Safe Third Country Agreement, you don't have the right of appeal of that decision. And you don't have the right of an automatic stay of removal if you pursue a judicial review. And so oftentimes, if you have a decision like my client did, denied on credibility, the only remedy that you have is to go to the federal court. You cannot introduce new evidence. You cannot, really make the kind of arguments that you may be able to make if it was an appeal. And after you file that judicial review, there's no stay on removal. Immigration could remove you at any time they choose to proceed with removal. And so I think that this is something that we really need to be looking at if we are going to have a fair system, the unequal treatment of refugees. Because if you were to sneak across the border surreptitiously and come to an irregular port of entry, like let's say Roxham, very well-known place in Montreal, and you file an inland claim, you do have the right of appeal, which is substantially different from a judicial review. You could introduce new evidence. You could be found to be a convention refugee because it's part of the IRB. None of that, and you have an automatic stay on your removal while you're waiting for your appeal to be dispensed with. And so I think that that's something that is very important if we're going to be advocating for very vulnerable individuals, notwithstanding all of the procedural fairness rights that we have in Canada for people. We need to be looking at the unequal treatment of refugees that is dictated not by who you are or the merits of your case, but where you file your claim. And so that's one thing that I think that needs to be really litigated in Canada. For me, it's ripe for a Section 15 constitutional challenge. And I would urge any interest group to really look into that. Because for me as a lawyer, working with one person at a time and not part of a public interest organization and not funded for public interest litigation, it's something that I would love to do. And I think that should be done. And so let's talk about how race, culture, economics, language, all of that play a role in the adjudication of refugee claims, especially if you come from a very marginalized community, from a poor family, your level of education is not very high. All of those factors by themselves produce a system that is very formal, certainly, a system that is not the easiest to navigate, and a system that is still, believe it or not, in today's times that we live in, still is presided over by individuals who have very, let's say, assumptions about members of certain communities based on stereotypes that have nothing to do with reality. And so my work as a lawyer, as an advocate, is really to try to challenge those stereotypes and to show that it actually creates a lot of injustice to individuals, because not everyone, and most people I would say, don't adhere to the stereotypes, right? And so these are things that I think are very important that we really look at in the legal profession, and how the law could be used as a weapon to really harm a very strong case that is genuine, and that there is genuine risk if this person were to be returned to their country. And so let's take a look at a mythical person that we have created in the legal profession, the reasonable person. Because so often I see decisions from the refugee board, or even from the federal court at times, where the person, the adjudicator, says it is not reasonable that Mr., let's say, A would behave in this manner if Mr. A was really afraid. It's not reasonable that they would not have left their country earlier, regardless the fact that the person testified, I didn't have the money to buy a ticket. Because economics, of course, in the perfect world that some people live in, have no bearing in a person's behavior. We pretend that that's not relevant. We pretend that a family that have lived together and do everything together would want to leave together, and that maybe the father will not just run away and leave his wife and children behind. And the fact that you may wait to leave as a family and you can't afford to leave as a family earlier, that by itself should not give rise to lack of fear, lack of subjective fear, which does not conform with the legal definition of a convention refugee, because the definition is a person that has a well-founded fear of persecution. So often I find the law being used to create artificial obstacles to individuals by relying on this reasonable person. It's not reasonable that you would not have disclosed your sexual orientation the minute you enter Canada. It's not reasonable that you would not have asked for protection at the border. Never mind, you've been waiting a long time to cross. You're tired, you're hungry, you're scared, you're distrustful because you've lived in a closet all your life, and you're supposed to suddenly have full disclosure with a perfect stranger that you don't know. So these are things that sometimes really frustrate me, anger me. And I've really tried, alongside with my legal advocacy, to sort of conduct my own sort of cultural, teaching, my own sort of making the member understand that this so-called reasonable person doesn't exist, maybe only in academia. So we see this kind of reasonable stereotype, or this projecting of what we expect people to behave. Never mind, we have a more nuanced understanding of what it means to be multicultural today in Canada. Let's take in the area of sponsorship, right? That has nothing to do with refugee at this time, but still very relevant because the issues are the same. I often look at decisions where a sponsorship has been denied, and it could be of a straight couple, it could be of a same-sex couple, doesn't matter. So let's say they question one spouse, and you don't know every detail, no matter how peripheral or small, irrelevant this detail is about your spouse. Okay, so a question may be, what is the name of your spouse, ex-spouse? Now, this is something you may not have really, discussed with your current spouse, because you don't even care so much about their former life together. But suddenly you're expected to know everything, and your inability to know that or to remember that with perfect recall may lead to a finding that this is not a real marriage. This is not a genuine marriage, because if it was, you would know all about your ex-husband, his or her shopping behavior, what they like to eat, their dates in the past, everything about them. And we don't hold couples to the same standard who are not going through sponsorship, and it doesn't invalidate their marriage. So think how awful it would be to have a perfect stranger that you don't know judge you and your marriage and your relationship and say, this is not genuine. So these are the things that many racialized communities face. And at some point, it's very, very insulting. Let's be honest, it is insulting, it's offensive to have a perfect stranger look at you, judge you, that don't know anything about you, and say, your marriage is not genuine, or you're not really a member of the LGBT community, or you're not, so-and-so, simply because you don't fit the image of what I would expect, or you don't behave like I would expect. So sometimes I think in Canada, we advance and we have all of these rights, and we extend all of these procedural fairness to people. But at the same time, we go backwards because we try to lump everyone into the same category and have one standard of behavior for everyone. And we lose sight of the fact that people are a product of their family that they come from, their family dynamics, their race, their religion. Like, I'm very different from my husband because he was raised in a very different setting, very different country than I. I'm from the Caribbean. He's a white Canadian. So there's certain very important differences between us, how we see the world, how we look at things, but we have common values that are also very important, but we're very different, and that's fine. Nobody comes to us and say, hey, your marriage is not valid because you don't know this or whatever. No, it's none of their business. But when we are going through a sponsorship, we bring to that that sponsorship, whether it's real or not, a level of judgment that, in my view, is very misplaced and very culturally inappropriate in today's world when we know better and we should be doing better. Same thing with refugee. If you don't remember dates, when I sit in a refugee hearing, when I sit as counsel and I'm listening to the questions and they ask a person something that happened maybe 8 years ago, 5 years ago, and if that person doesn't remember or give an incorrect date, they are oftentimes not believed and not deemed to be credible. And as I sit there, I'm like, man, if that was me, I wouldn't remember anything. And I may be, seen to be lacking in credibility. And so the same board member that is asking these questions and making all these judgments, I've often looked at them and thought, I bet you wouldn't even know if you were asked 5 years ago what you did on Christmas Eve. Well, not Christmas Eve, that's a different thing. Let's say January 20th, 2009, or, another date. What did you do on that evening? Many people would be scratching their head and it's like, I don't remember. I just don't remember. And when we look at the importance of a refugee, hearing to the person, what could be more important than their life? And so we should not be asking some of these questions because in the grand scheme of things, what does it matter? These little details to the most important question, are you at risk? So sometimes when I do refugee hearings, 2 hours, 3 hours go by and a single relevant question has not been asked by the board member because they are obsessed with the little details that, in my view, have nothing to do with the one important question. Is this person at risk? And so there is that obsession with the little details and not asking the most important question in a very direct way. And so these are some of my pet peeves as an immigration lawyer when we hold people that come from such different backgrounds to a standard and demand that they think like we do without, first of all, asking a simple question. Is it fair to them? Is it fair to them that we ask them these questions and we expect this response, but we don't know nothing about their background, how they were brought up, whether they even had breakfast this morning and the money to buy a meal before they came to the hearing, their mental health, right? We're just coming out, if we've come out at all, of a pandemic. Nobody really looks at the mental health and what the pandemic has done to people. And so, I think that refusal to ask the real questions out of maybe a sense of it's not politically correct is a disservice to the refugees, to the people that come here and have a certain image of what Canada is, but then the reality is oftentimes there's a disconnect. And so I think that if we really want to be fair to the people, and of course we have a legal mandate to be fair, we should not just have legislation and have a process, but we should actually do real justice and behave in a manner that all people could relate to. And that's one of my main frustration as a refugee lawyer, because I see a sort of game that is being played, a sort of, charade where we ask these questions. So when we look at refugee adjudication, there's a certain format that board members are trained to follow, and they don't deviate from this format. They go through the exhibits at the commencement of the hearing, they identify the issues, and all of a sudden, let's say your name is Jane Doe. Jane Doe no longer exists as Jane Doe. Jane Doe becomes legal issues that are very compartmentalized, and the legal issues are likely credibility, IFA, internal flight alternative, state protection, and so it goes. And all of a sudden, nobody cares about Jane Doe's life, Jane Doe reason for coming to Canada. It's all about IFA and the legal tests. Can you relocate within your country? Can you do this? Can you do that? And the real questions may never be asked. And so we need to start looking at people as people and just apply common sense, right? Rather than just follow a script. Sometimes I look at board members and I see them reading off a script. Sometimes they forget that they're sharing and they leave their script on the screen, and I see their questions and they're just like following the script, no matter what the answers are. It seems irrelevant. They're just obsessed with going through a little script that they have written out in a very academic manner. And they're not really listening to the answers. And so these are things that I think we need to maybe educate the people that are adjudicating refugee hearings and say, look, let's have common sense. Let's look at the law and let's ask the questions that are important, that are relevant, that the people can relate to. This is not a history lesson. This is not going off on a tangent and expecting someone to behave in a certain way and to disclose to people their orientation or this or that, even though you may come from a deeply homophobic family where your parents are evangelical pastors, or, you should file a refugee claim at the port of entry, even though you come from a communist country where you don't trust authority figures at all. So these are things that we really need to educate the people who are making these very, very important decisions. So, in the case of Baker in Canada, one of the most important early cases where the Supreme Court looked at procedural fairness and what that means, the Supreme Court set out like 5 different factors that inform procedural fairness. And one of those is the interest at stake, the importance of that to the individual affected. And when I look at refugee hearings and I look at the interest at stake, it's the simple, most important interest, your life. What could be more important than that? And yet we don't really look at the significance of that sometimes. Board members, I think, they get so jaded sometimes, not all, but many, they get so jaded, they're so inexperienced, they don't have the life experiences sometimes, or the cultural understanding and appreciation. They just turn up from their homes. Now they're all doing it from their home. They have their little script, they ask their questions and they go away. And they don't take the time, they're so busy. They don't really take the time to look at the person, really look at them when they're testifying, look at their expression and listen to the answers and really know the country condition documents sometimes and know what's going on in the country. And the context is everything, right? So some of those are my pet peeve. And I think that there is a need to have more stakeholders, maybe like myself, people that work with so many individuals, really listen to us, talk to us, and learn from us. I learn a lot from my clients, and learning is a lifelong process. I love to learn. I learn sometimes from little children. You know, I remember a couple of months ago, I was in my law firm, and this little child, he was about 10 years old. He was sitting there and looking at me with a very serious face. I had no idea who he was. And he called me out. He's like, "Hi, are you my lawyer?" And I'm like, "Who are you?" And he told me his name. And I'm like, "Yeah, I'm your lawyer." And he said to me in a very serious voice, he says, "You know, I really want you to win my refugee claim." And I'm like, "Oh, tell me about you." So I took him into my office. I sat him down and I'm like, "Talk to me. Why is this so important to you?" Because normally children don't come up and talk to me like that, so boldly. And he says, "Well, I'm really good at soccer and I really want to play soccer professionally. And my coach has invited me to 3 countries to play soccer. But because I don't have my papers, I'm a refugee. I can't leave Canada." And, you know, I was so struck by this child. And I said, "You know, I'm going to make sure that I do my best to win you and your mom's refugee claim." I said, "Let's shake hands and let's shake on it." So we shook hands very seriously. And I won his refugee claim. And, you know, he wrote me a note, a handwritten note that said, "Thank you for winning my refugee claim. When I'm a professional soccer player, I will always remember you." And I framed that note and I have it on my desk and I look at it. It keeps me humble. It keeps me grounded. It reminds me of why I became a lawyer. And I learn a lot from that child. And sometimes we need that, you know, experience to keep us humble, to remind us of what we do, the importance of what we do, and why it matters. Because ultimately, it's not about me wearing a fancy suit and turning up and looking nice. It's about that child and his mother not going back to their country and what I can do to facilitate that. And I try to keep that in mind.
Thank you. Thank you a lot.
I
It's
think
just like if you, yeah, if you need a minute to wrap up, it's okay.
No. I'm good. I'm good.
Well, thank you so much for like particularly this last story. Yeah, it's certainly meaningful, and yeah, let us think of what is the real questions to answer and what's really fair to people, and the way how we like the law and the process is changing that. So thank you so much. That was really important to hear. Thank you. And I would love to hear also Dr. Martin. I'm excited to see to hear your perspective on that. So I'll leave you the floor also. Thank you.
Thank you very much. It's not easy to talk after Adela because she summarized everything and analyzed everything so correctly. If I would like to summarize in a nutshell what we should focus on when we talk about refugee resettlement or refugee sponsorship, I could just say that please try to imagine the whole story, what Adela told you, without lawyers and without effective remedies. So in a nutshell, resettlement has no clause such a level of accountability and transparency as the in Canada refugee determination. So we have very serious challenges. And I think that what I try to do is to analyze it, that if we see the whole program, can we identify steps and groups, communities, or situations where especially you find oppression or discrimination or any type of issue which create a challenge, a systematic challenge for several people. theoretically, resettlement is wonderful. I love it. When first time I heard about it, let's say 25 years ago, I was young and I admired the Canadian resettlement program. You know, like, I mean, you help refugees to start a new life. They arrive with a clean immigration paper, like a dream come true, like it's better than winning the lottery, you know? So really, resettlement was something fantastic. And, you know, the whole heroic time in the 1970s when, you know, the Vietnamese boat people came and churches and communities, they welcomed families in their own homes and helped them, and everybody became so successful and integrated and happy Canadian. So it was really a model which the whole world could have copied and admired. I remember when I started to work at Catholic Cross Cultural Services in 2001, and I find old files. Can you imagine at that time, one refugee sponsorship file consisted of one legal size paper. That was the document to submit to immigration. This is how we started. If you know now immigration, you know that even the guide, just how to fill out, let's say the generic form, it's about 50 pages just to learn that how to answer on the questions on the forms. So yes, we have challenges. Yes, you have issues, but I think even an outsider can see that when you talk about the situation, let's say in Afghanistan and Ukraine, and you see that even the politicians, they considered both of them as priority. And do we have the same process for them? No, very, very different. And this is very disturbing. This is when you divide communities, you make them hate each other or compete against each other in a negative way. It is something which should not happen. And there should be an overviewing body to express it that, yes, we want to help everyone. And yes, we have to be fair and we have to try our best. But there are ways which are not acceptable. And when you see, for instance, in the Afghan communities, let's say the Hazara minority or some other groups, I mean, they have extremely huge challenges. And the government or the bureaucrats at the government, they did not allow the program to run as it's supposed to run. I remember in 2001, 2002, when IRPA came in force, like, oh, we were so happy, like, oh, this new modern law and the regulations give us power. And you know, it was clear now how the resettlement works. Everybody knows who is who. They introduced the so-called co-sponsor in one word, and like a lot of new things which gave us hopes. And then slowly, even the law basically didn't change, but those who implement the law, they changed it, and it became really a very challenging situation and very negative for several communities, especially particularly to some of them. Not having effective remedies, not having any legal venue to go once you have a negative rejection, only this, you know, like, okay, fairness procedure, that is not really something good, or go to the federal court really from the other side of the world, and then you arrange things. Just as Adela mentioned, it's for the privileged, for the rich, for the educated, for those who have the connections, that the system might work. But an average person, especially in the refugee category, where it shouldn't be, it should not be a factor. All these things like the financial situation, the social support, and educational background, unfortunately, it cuts everything, and we totally lack transparency and accountability. Actually, it's a shame, because it's a Canadian system, and we should have Canadian system standards, regardless whether it's in the visa office in Bangkok, Thailand, or it's in Toronto, Ontario. So we should have same expectations and requirements. But let's see that if we talk about the practice of refugee resettlement or refugee sponsorship, does it particularly affect on a particular group? And working in resettlement, for me, of course, I went all over the world in different places, and I don't want to compare refugee lives or refugee stories, and nothing can be compared to the interviews I conducted in northern Iraq in the refugee camps with Yazidi women. Like we had 3 members of parliament from Ottawa, and all of them, they left the room with uncontrollable crying, because you cannot listen to these stories. So really you find in every community, every part of the world, unfortunately, refugee issues are really very serious, and I'm very happy that in Canada we have a system to help these people. So definitely, let's say the Yazidis is one of the most persecuted community. However, when you go to the camp conditions, when you see how they live in the internally displaced camps or refugee camps, you find air conditioner, you find big TV and stuff like that, which shows that, like, okay, there are means. When you go some other parts of the world, and particularly in sub-Saharan Africa, you see the conditions which really shows that the challenge is great. And why is it important? Not only because even the survival rate is lower. Like, I have to tell you that in the last 2 decades, I was working on resettlement. We lost several refugees in the immigration process, waiting. Like one situation, I have a refugee just called me yesterday from Africa. He has AIDS, HIV positive with the symptoms of AIDS. He's totally ostracized in the community, of course, and unfortunately, of course, and this is how it works. He's waiting in the resettlement process for 7 years. The Canadian Visa Office is aware of the situation. We provided all medical information, but even the sponsor is tired already to try to push the case. Where is the fairness? Where is the procedural fairness or equal processing? You know, like having some refugee processes in some parts of the world, which is really quite reasonably fast. And then you go some parts of the world where even they know that this person is literally dying and the visa office is unable or unwilling to process. We lost, there was a case of an African case also, a woman with breast cancer. We reported to the embassy. Yes, they promised they will expedite the process, and we waited several months, and we reported every time how the situation deteriorating, and unfortunately the woman passed away, leaving the small children behind her alone in Africa, and the process finalized only much later than that. Like, these situations should never happen, or if it happened, there should be remedy, there should be publicity, there should be something that, like, okay, this is not okay, this is not how it's supposed to be. But then let's see about the numbers, because you know, in inland process, it's spontaneous. People are coming, going, who is arriving. You know, the government is not responsible, but in resettlement, everything is planned. So when you see the figures, you can conclude, is it fair? Is it correct? So let's see, according to the United Nations High Commissioner for Refugees, Africa hosts more than 40% of the world refugee population in need. If you add also sub-Saharan Africans in other countries, in Asia, in Middle East, in Europe and other places where they even in Latin America, I met a lot, then the refugees from sub-Saharan Africa is about 50% officially of the world refugee population in need of help. So I did a small research to see that what Canada did on resettlement between 2015 and 2022. The total number who were resettled, who got as a landed immigrant, is 227,000 refugees in this period of time. And then I calculated these refugees came from 126 countries. And then I calculated the 41 sub-Saharan African countries. And you find out that 29% came from there. If you go to the government sponsorship program, it's even less than 25%. So that shows we have really a problem. This problem also exists not only at the selection, and I'll talk about the selection more, how to choose who will get this privilege, this extra chance that his life will be saved and he get a durable solution, but also at processing. Previously, it was so simple. You went to the Immigration Canada website and you could check the processing times. And you find out, and we had this everywhere, that like, okay, how many months is the process at this visa office or that visa office? And now it's very complicated, it's hidden. In several places, the processing time is not available even. So it's not so simple to do a research nowadays to compare, but I think that we should get this information. And then I thought, you know what, let me go to my own database. So I just checked in the last approximately 5 years, the files went under my hands, and I find very interesting data, because the non-African cases, the average processing was 800 days. And for the African cases, the average processing was 1,100 days. Significant difference. It's about life of people. Is it a coincidence? Is it a coincidence of this percentage of participation in the Canadian resettlement program? Is it a coincidence to have this processing time? Somebody should check on it. Somebody should see what is really happening and why is it important. I decided just to quote 3 sentences. According to the Institute of Economics and Peace's Global Peace Index 2022, 5 of the 10 least peaceful countries globally were in the region: the Central African Republic, the Democratic Republic of Congo, Somalia, South Sudan, and Sudan. Additionally, Burkina Faso, Mali, Niger, Nigeria, and Somalia ranked among the top 10 countries worldwide most impacted by terrorism. During the reporting period, a worsening trend of political instability and authoritarianism was apparent on the continent. A number of coups, military coups, were staged in 2020 and 2022, including successful military coups in Burkina Faso, Chad, Guinea, Mali twice, Sudan, and failed ones in Central African Republic, Djibouti, Guinea-Bissau, Madagascar, and Niger. Doesn't it show that probably if we want to be fair, then we should not ignore the region? We should try our best and provide equal protection opportunity as others in the world. The region of Sub-Saharan Africa has for a long time been tremendously underserved by Immigration Canada in every categories, actually, not only refugee categories. It's very, very interesting. Why is it that we have a needy situation? I think that most of us don't follow all the media, and we don't know about the so-called silent wars or victims of silent wars in the last 70 years. So let's take the time after the Second World War until now. According to official statistics, more than 18 million people has been killed in African wars locally. When we talk about refugee sponsorship, even the processing places is very important. You have access. Previously, we had access under the so-called source country class. In 2011, the Canadian government decided to eliminate the source country class. That means that from that moment, no refugee allowed to enter into a Canadian embassy to apply for refugee protection overseas. Everybody must come on a way that first they have to leave their country's international boundaries and go to another country and apply there. What is that? It's helping for human traffickers to have business. It's really not fair, especially countries where the transportation is difficult, where the safety is a concern, especially for women. Like this issue was eliminated from the Canadian Immigration Refugee Protection Act, I mean, from the regulations, and the effect is there and significantly, definitely effect on African communities. Also, when you see that, for instance, in Europe, we have 10 embassies processing refugee visas, which is curious because, like, forget about the Ukrainian crisis, and anyhow, they don't need refugee visa. But we don't have too many refugees in need of protection who are resettled in Canada. And in Sub-Saharan Africa, we have 4 Canadian visa office processing refugee applications. Why? We don't have more? Oh, we have 18. But Immigration Canada decided only to choose these offices to process refugee resettlement. How does it affect? It affects on delays and problems and several very difficult situations for refugees, how to go to an interview, for instance. I had a family in West Africa, and I couldn't believe it. They got an interview note, and the day when they had to leave the country to go to another country where the Canadian embassy is, actually between the two countries, in that country there was a military coup, and there was a martial law. They locked the borders. And this family, they went through everything and they showed up at the embassy. So like, I mean, you know, when you want something, when you need something, you go through on several hardships, but it shouldn't be like that. We shouldn't really make people go through on dangers just because the Canadian process became so complicated. So let's go back quickly to the process, because this was the practice and the figures. But let's see how the process entails. And the first part is selection. Selection by the Canadian government to the government-assisted refugees program is a mystery. And this really creates serious problems, because not only the small numbers from oppressed communities or marginalized communities, but also in the selection, nobody clearly knows how it happens. And there are no remedies, of course, when you are not selected. So, for instance, you know, the principle says, oh, the most vulnerable, whatever. It's not true. No, they don't select the most vulnerable. It's much more complex than that. There was even a riot created by the Canadian visa office in Ghana when in 2005, there was an influx of Sudanese refugees, and the Ghana government was you know, they didn't know what to do with these refugees, and they asked the Canadian embassy said, okay, we can process them. However, the refugees who lived in a camp for 10 years, and they saw the Sudanese refugees just arrive, and they have been selected by the Canadian embassy, they first expressed, you know, that they are not happy, and they demanded that they should be listened to. But when it didn't happen, then they burned the camp and they went to the bush. So when you do cherry picking in resettlement, when you are political, you make political decisions with refugees, it can cost lives. This is exactly how, like, Angela Merkel, you know, like, announced that all Syrian refugees are welcome to Germany. And I was in a mission trip with several Canadian volunteers in the Middle East. And once these people heard the German chancellor to say that, actually they refused even to communicate with us. They didn't want to come to Canada. They wanted to go to Germany. And it was totally unrealistic because they had no way to go there. So I think that really we want to see that, like, how the selection goes, how it's professional and fair, and how people, you know, like when the government announced the selection program, for instance, the Somali Madiban, the clan which was identified as an oppressed one within the refugee camp. However, who did the selection? The local staff, who, based on corruption or mismanagement, selected exactly the oppressors in the group. So when people arrived, we had cases in Hamilton and other places that basically not only those arrived who are the victims, but the oppressor also. Why? Because there was no overview. Similar situation happened with Togolese. Just because the Canadian immigration admitted that they cannot help the Togolese refugees because they look alike like the ever-speaking refugees from Ghana. And the local staff at the Canadian embassy said, why should these people go to Canada? I am the same tribe, the same ethnic group, and I cannot go. And therefore they stopped the program. So I think that when we are in this level, then it really shows that an overview is needed. We need simplification. We need openness. We need to do something, because now the number of forms and the number of questions there is not only confusing, but it's really killing cases. A lot of people with their own mentality, with their own culture, they don't understand the Canadian mentality. Like one good issue is that, for instance, in I think it's Schedule A, they asked that, did anybody help you to fill out the forms? And if you put no, it means the visa officer will assume that you speak perfect English and you know everything about immigration, because like all these difficult questions has been answered. But if you say, yes, somebody helped me, but you put that, yes, and somebody I paid him or her, because there is a second question, then you jeopardize your case, because then based on that, they can reject or express concern that like, okay, something is wrong because you didn't use a Canadian registered immigration consultant or a lawyer. So these are the traps, and nobody watch it. The forms are more and more complicated every year. So I think that the selection, the process, and even the interview need revisit, need a civil committee to overview, not only professionals. And I think definitely it's important to see also that the intervention on local stuff should not happen. It might sound strange, but for instance, we had several cases of discrimination against Christians because in the Canadian visa office, the staff who worked were Muslim in that particular visa office. And unfortunately, it was very negative for them, and they couldn't really express that they have religious persecution and other issues. The same about gay, lesbian issues. It's very, very difficult. So finally, let me just say a few words about the settlement outcome, because again, in this program, it's so easy to compare, so easy to see that what result on what and in which community is affected. Unfortunately, I think that most of us who works on settlement knows about the tragedy of the Somali community, and it shows that if we allow the government to make decisions instead of the civil society, if they don't use our communities, if they don't use professionalism, but they do politics, then we have dramatic situations and we don't have success in integration. So thank you so much for listening to me, and I'm ready for any questions. Probably it shows a small picture of a very complicated situation, but I think that if you just start to think about this, then already we got a good result today. Thank you.
Thank you so much, Dr. Martin. That's very, everything you said is very, very important. And like, I completely agree. I want to reiterate the same points, the way the process, the selection and the process are not are not based on who's more eligible or who needs it more, but it's more politicized. And I also like saw a lot of examples of that through my work. And I wanted to reiterate a point that like that the processing times is different, and it's not fair from one location to another, from one region to another. It could be up to 3 years, but also that is on top of years of waiting sometimes for people who are living in refugee camps in sub-Saharan African countries or in other regions. One other example I wanted to highlight is the refugees in camps in Papua New Guinea and Manus and Nauru Islands who were like detained because of the Australian offshore policy, and like they've been waiting in camps for over 10 years, and then of 200-300 applications that were submitted, 10 were admitted after 2 years of being on hold during COVID, and 2 more years of processing on top of 6-7 years of waiting in the camp. So yeah, those things we like I just wanted to reiterate those experiences because I agree how unfair it could be and how politicized it could be. Thank you so much. And if anyone have questions, you can speak, or you can type your questions and address either Dr. Martin or Adila.
I just want to make one quick point following on Dr. Martin. There are very important differences between how we adjudicate, let's say, a failed refugee claim overseas versus inland. So I've done a lot of judicial review of overseas decisions where claims were denied. And when I looked at the adjudication process of making that decision, there is no comparison between an inland adjudication and an overseas. And I've had many discussions with Dr. Martin about this because I feel so strongly about this. And for me as a lawyer, is, I can't even comprehend why we have such a huge discrepancy between the two. So quickly, in 2 minutes, I want to go through, because I think it's really important that we look at this, the double standards that are used. So if you file an inland claim from within Canada, you have legal aid funded lawyer. You have a specialized tribunal, the Immigration and Refugee Board, with members that are deemed to be specialists in risk assessment. You have the weight of the NDP, National Document Package. You have the jurisprudence, and you have members that are trained in all of that, and they assess it. You have the gender guidelines, the SOGIE guidelines, you have all of these things, right? Theoretically, we should also have the same for decision-making with refugees abroad, but we don't. We don't. If you look at a decision that comes out of a visa office, 9 out of 10 times, the visa officer knows nothing about the law. It's not based on law. It's notes, sometimes more than a real decision. And there's no assessment of the country condition documents. There's no reference to case law. It's not recorded. So in an inland claim, when I do an appeal or a judicial review, I routinely look at the audio recording. I get one of my staff to type it up, to listen to it, type it up, and I look at it. And I base my legal arguments on the recording. There's no recording. So if the officer stated so, even if that's not accurate, as a lawyer, I have no way of knowing whether it's true or not. There's no recording. And so the reasons are very inadequate. There's no appeal. There's only judicial review, right? And so, like nobody has, these refugees don't know about NDP. Their visa officers don't know about NDP. And so when I look at all of that, I say to myself, you know, these individuals in these refugee camps have to be some of the most marginalized people in the world. No technology, no access to, you know, some of the things that we take for granted here that is paid for by the taxpayers here for refugee claimants. And we give them the whole range of legal services and procedural fairness within, you know, the boundaries of what I said earlier. But it's there, it's available. But overseas, even if you want it, it's not available. And there's no argument as to why we have such a vastly inferior adjudication system for claims from abroad. Nobody has ever, from my research, offered any rationale as to why it exists, the two very unequal systems. And I can only assume that because these refugees abroad are so poor, so powerless, so marginalized, that nobody really litigate and say that, you know, this is wrong. Also, you know, the charter does not apply to them. They're not here. So to bring a charter argument under Section 15, that unequal treatment, well, the argument is, does the charter apply to them, right? No, it probably doesn't. So this is something that I think we need to really look at and say that it's not fair, it's not right, and we will not allow it to continue. We should not say that this should continue at all if we really want to be fair and advocate for some of the most vulnerable refugees in the world. That's just my 2 cents, because I have looked at the two systems side by side and I can't wrap my head around why it's so different. Dr. Martin, do you want to talk about that very briefly?
I appreciate this is exactly the issue which I wanted with some example to show, but this is the legal consequence exactly. Yeah.
Okay.
Thank you again. Anyone else would like to add or raise questions? Yeah,
If you are
go
waiting
ahead.
for a question, can I say a comment?
Sure, take your, yeah.
The Canadian immigration system is considered really good compared to other countries, particularly the resettlement, refugee resettlement. And we have a lot of policies, as Adela mentioned, in Canada, and we consider ourselves as a leader of the world in equity and anti-racism issues. I think it should be part of our mandate also, not only to view the Canadian system, but also to point out several places in the world. For instance, right now I'm in the Dominican Republic, and I see that Haitian people, how deported, arrested, and sent back to Haiti, where there is a war situation, but nobody talks about it. And walking on the street, I mean, literally it happened with me, that going with the Ukrainian lady and the Haitian guy and me, and three of us walking on the street, and the police come, they saw there is a black guy, they grab him and they arrested him because they thought he's from Haiti. I mean, without legal process, without anything, mass deportations are going on. Nobody speak about it. Nobody speak up for these people. We are waiting until a huge war will start with lot of victims. So I think we should see that how immigration works in Canada. I agree, but also we should include that, you know what, when there is something is so wrong and so close to Canada, then we should speak up for them too. Thank you.
Thank you. That's beautifully put. Like we don't have to wait for a war to actually help or to support people in need, or like, yeah, it doesn't have to be war to fulfill the definition of reasonable fear, like Adela put it.
This is a very quiet audience.
I was gonna say no questions at all. You're a very convincing key speaker. Well, if there are no questions, I mean, if you would like to add other things, also, we have until 3:30, so I would love to hear more from you also as well. So feel free to share.
I would love to hear more from Dr. Martin, because I see him as a walking encyclopedia. I go to Dr. Martin when I have a question. He's my go-to person. So Dr. Martin, you are based in the DR. Tell us some of the things that you see there that, you know, it just strikes you as so unfair.
And in the last few weeks, I had experience actually following migrants in Central America to the US border, and to see how it works. It's quite an experience. And these people might end up in Canada, actually, in the inland protection program, because there is no resettlement working from here right now. And that is also a question why. But if I could speak a few minutes, I would talk about program integrity. And that is an important issue, because unfortunately in 2017, in the Canadian Immigration Ministry, the bureaucrats decided to change how they deal with sponsors and sponsorships. And previously, this was a very autonomous program. And when Adela mentioned that, well, nobody make any legal challenge for the overseas process, one of the reasons is because I think even we were autonomous, but we control ourselves not to create a controversial situation with immigration in Canada, not to make too much conflict, because the sponsors were happy to do their job as they could. However, in 2017, the government decided to change the sponsorship agreement, and they made it extremely difficult to keep it and to get new sponsorship agreements. And that affects on the communities who want to get now in sponsorship, because practically they reject 99% of the applications when it goes to, if somebody wants to become a sponsorship agreement holder. Also, Immigration in Canada decided that they implement their methods on integration and how to help people to settle. and their method is the worst in internationally, because they don't teach independence to the newcomers. They corrupt them with automatic entitlement things like government support and housing and don't go to work. And previously, our program, in the civil resettlement program, we were extremely proud that practically no privately sponsored refugee learned the word of welfare, because they are strong, they are survival, and they got from the community all the help. But now it's the opposite. And unfortunately, the new rules make it extremely difficult, especially from ethnic background. If somebody wants to sponsor, like the Eritrean community is suffering, the Ethiopian community, Somali community is suffering on the extreme financial hardship, because even if you want to sponsor your own brother or sister, you must come up with $10,000s in cash from a taxed income. So I just wanted to summarize that we have serious problem in the sponsorship program now. And if there will be some changes, then unfortunately it affects very negatively on the outcome, how refugees will be part of the Canadian society. Thank you.
So I see that there's a question in the chat that says, which misconceptions do you frequently hear about the legal process for the refugee community? How can public health practitioners help with clearing them? And I think, if I may answer that, because I do on average 10 refugee hearings a week, which misconceptions do you frequently hear about? So I think that mental health is certainly a big issue, because mental health impacts concentration, focus, ability to recall with precision, dates, names, events, things like that. And those omissions from the testimony or the basis of claim document when you draft it could lead to very negative credibility findings or plausibility findings, which are often fatal to success in a refugee claim. How can mental health practitioners help with clearing them? I think that mental health practitioners could work more closely with refugees in terms of offering not just a 1-hour assessment from which flows a report, because then very little weight is placed on that report. And basically the tribunal and the federal court say, well, this is a self-reporting, this is not really diagnosis. So I think if refugees had more timely access to mental health professionals that get to know them, see them, and be able to provide not just a singular report, but case notes, and had more frequent meetings with the claimants or the refugees, it would go a long way towards establishing that credibility with the tribunal and with the court. So that's a way, because if you're meeting a very traumatized person and you're coming from the perspective of, understanding the impact that trauma has on memory, the IRB board members are not trained for that. They're not mental health professionals. They don't understand that. So they need to work hand in hand with mental health professionals. And the role that the mental health professionals can play is doing the assessments, providing the case notes, working with the claimant, even maybe coming as witnesses at the hearing to corroborate, yes, I've been seeing, indicating to the board that this person has mental health issues. Nobody's going to take my word because I'm not qualified. But if I had to support me in saying that, a mental health expert, then we work together very well. So that's my response to that question.
Thank you. And I also reiterate that mental health, from my experience, was deterrent for refugees in many cases to remember things. Like, it's just hard to remember those details. And again, they're being judged based on those and being to fulfill the reasonable expectations and standards. So thank you for stressing that out again.
And just quickly, one point, the thing that we don't talk about, the elephant in the room, is the prejudice of delay, right? Delay in hearing these claims. Sometimes 4 years, 5 years go by from the time the person comes to Canada and the day they attend their hearing. And that delay is prejudicial to only one person, the refugee claimant. Because the question is, an issue is forward-looking risk. Okay, so are they really interested in finding you? It's been 5 years now since you left your country. Like, who's looking for you? So we have victims of domestic violence. Oh, well, you know, the guy probably has moved on, has another woman. Like, why would he be interested in you? You're not that beautiful. That's the thought process that's going on in the board members' mind. I can see it, right? So these are things that are very prejudicial. But again, nobody talks about it. And it's the fault of the tribunal. And yet the refugees are paying the price, forward-looking risk. So these are some of the things that I've observed.
No, these are certainly all very important things. And yeah, definitely thank you for sharing, articulating those things. I know everyone who's working with refugees have come across these issues more or less, but you have a bird view perception. You can tell us exactly, articulate how these things are happening on a legal level. So thank you for sharing all this information. It was very, very informative, and I really appreciate your time and your experience. I'm gonna just give 2 more minutes if anyone wants to ask a final question. Otherwise, I think we can conclude. Thank you, everyone. Any final thoughts?
I'm going to put my email in the chat if anyone wanted to get in touch with me, just so that you know how to do so.
Yeah, I do the same. So please feel free to email me questions which we could not answer right now. I'm very happy to chat with you, okay?
Yeah, I have a passion for working with refugees, and I really enjoy, out of everything I do, I really enjoy doing refugee hearings.
Well,
Okay,
thank
well,
you.
Dr. Martin, nice to
Thank
see
you
you.
so much. Thank you for your time. I think we can conclude this webinar today. This will be posted again on YouTube, and it will be sent to everyone, so you'll receive a copy of that. And have a wonderful day, everyone. Thank you.
Thank you. Bye.
Thank you.
Take care. Bye-bye.
Thank you so much. Bye, everyone.